a property manager must disburse funds as directed by the parties. Issue. In light of significant credit problems, the tenants offered to pay a full year's rent in advance if the landlord would accept them as tenants. The landlord ultimately accepted, and the parties entered into an AAR residential lease agreement. The tenants took possession and paid the entire year's rent in advance. Is the property manager required to hold the rent in the brokerage trust account to pay the landlord on a monthly basis? Answer: no. Based on the facts presented, the parties agreed in the lease that the full year's rent would be paid to the landlord. Accordingly, there is no obligation for the property manager to maintain the rent in the brokerage trust account. Rather, the rent should be forwarded to the landlord as the parties agreed. Note: a lease owner is not permitted to demand or receive security, including prepaid rent, in an amount in excess of 1/2 month's rent. However, a tenant is not prohibited from voluntarily paying more than 1/2 month's rent in advance. Maintenance man cannot perform move-in, move-out inspections of rental property. Issue. At the time any tenant in the apartment building moves in or moves out, the property manager sends the maintenance man to handle the move-in or move-out inspection. The maintenance man is not a real estate licensee. Can the maintenance man perform the move-in or move-out inspections? Answer: probably not. ADRI Substantive Policy Statement, 2005. 04 specifies certain acts which can or cannot be performed by a non-licensee. One activity specifically not allowed by a non-licensee is perform a walkthrough inspection. Therefore, the maintenance man is probably prohibited from conducting move-in or move-out inspections on a rental property. Property management agreement terminates upon death of owner. Issue. Under the property management agreement for the rental of the owner's home, the property manager collects security deposits and rent from tenants. The owner of the home has now died. What is the property manager's responsibility regarding the rent and the security deposits of the tenants? Answer: a property management agreement is a contract for personal services which terminates upon the death of the owner of the home. Upon termination of the property management agreement, the property manager is required to immediately contact the personal representative of the deceased owner's estate and provide any rental agreements, keys, and other documents to the personal representative. See ARS, paragraph 32, 2173, B. 1. Property management company's right to collect rents terminated at the trustee's sale. Issue. The residential property was foreclosed, and the bank took the title by way of a trustee's sale. The tenant occupying the property was not aware of the trustee's sale and continued to pay rent to the prior homeowner's property management company. In fact, the tenant paid 2 months of rent after the trustee's sale to the property management company. What should the property management company do with the post-trustee's sale rental payments? Answer: once the lender took the title by way of the trustee's sale, the property management company no longer had a valid property management contract. The property management company should contact the lender, explain the situation, and forward the rental payments to the lender, the new owner. Property manager is not required to hold prepaid rent. Issue. The brokerage represents the landlord. The tenant has requested to prepay all rents at the beginning of the lease term. Can the brokerage deliver the prepaid rent to the landlord, or must the brokerage hold the money in trust in the event the landlord breaches its obligations under the lease, i.e., the property is foreclosed during the lease term? Answer: a property manager does not have an obligation to hold prepaid rent in trust in the event the landlord breaches the lease. A landlord is entitled to demand the rental funds when they are received, less any property management fees, regardless of whether the tenant pays on a monthly basis or in advance. Lines 63 to 64 of the AAR Property Management Agreement provide, for example, that broker shall not disburse tenants' refundable security deposits, prepaid rent, or other prepaid funds to owner until earned unless instructed otherwise by owner. If, however, the broker retains the prepaid rent, it must be held in the broker's trust account. Property manager not obligated to report felony issue. The property manager furnished the 2-day notice to inspect the tenant's apartment. The tenant was not home at the time of the inspection. During the inspection, the property manager saw a handgun with a silencer. Is the property manager required to notify the police of this handgun with a silencer? Answer: no. Although a handgun with a silencer under certain circumstances is a felony, ARS, paragraph 13, 310I1A, 8. A real estate licensee, or any other member of the general public, has no obligation to report a felony to the police note. Inasmuch as a felony is being committed in the tenant's apartment, however, there may be grounds to terminate the lease. CARS, paragraph 33, 1368. Arizona Realtor, Our Magazine, June 2010.